fringe theories. I think I have a sense of what some of those are from reading the book, but for the uninitiated, what's an example of a fringe theory? And how does a fringe theory make its way into Supreme Court jurisprudence? How does that make any sense at all?
Yeah, so a fringe theory, generally speaking, is just a theory that, lacks a basis in law, and is not supported by a majority or even a strong plurality of the entire country. So it captures only a small minority of the country. So an example of a fringe theory that I think has made its way into Supreme Court jurisprudence is something that I think is related to the Stop the Steal movement, which itself is kind of a fringe theory. So Stop the Steal movement, of course, maintained that the 2020 presidential election was stolen, illegitimate, involved widespread voter fraud, and kind of resulted in an attempt to overthrow the results of the 2020 election. What people might not know or might not remember is that theory is actually related to a principle of law that the Supreme Court has now placed in Supreme Court opinions, and that's this independent state legislature theory. The idea that state legislatures and state legislatures alone, to the exclusion of state courts, to the exclusion of state executives, they get to set the rules regarding federal elections. And it was based on that idea that John Eastman and other people recommended that Vice President Pence could just throw out the votes, effectively send the election back to state legislatures, and state legislatures could pick a president, notwithstanding how the people in their states had voted. So that precise version of the theory, of course, isn't accepted by the Supreme Court. But, right, like another version of the independent state legislature theory, which is, yes, state legislatures have the primary role in establishing the rules regarding federal elections, again, to the exclusion of state courts and state executives, that has made its way into Supreme Court opinions. That was the concurrence in Bush versus Gore, where the Supreme Court stopped the count in the 2000 presidential election and handed the presidency to George Bush. Also made its way into now a majority opinion in Moore versus Harper, the independent state legislature theory case, where the court rejected an extreme version of the theory, but said some version of the theory is actually a part of our Constitution.
Is the major questions doctrine a fringe theory?
The major questions doctrine is the idea that when courts are interpreting statutes that authorize administrative agencies to enact regulations, that courts should place a thumb on the scale against the agency in certain kinds of major questions cases. It's an exception to textualism, how the Republican justices usually want to read statutes, because they're not going to interpret the statute according to the best interpretation of its words. Also, it's a way of incorporating the Republican Party's opposition to regulations into the law, because how does the court define a major question? Based in part on the idea that a regulation is politically controversial. So what regulations have they defined as major because they're politically controversial? The Clean Power Plan, as well as student debt relief, as well as a test or vaccination policy. These were all regulations where there was a clear partisan divide as far as who supported the regulation and who opposed it. So it's a way of incorporating, I think, Republicans' kind of fringe positions on climate change, vaccinations, and student debt relief into the law.
Now, on the major questions doctrine, to the extent it's a doctrine as opposed to a fringe theory, are the conservatives consistent in how they apply it? And the reason I ask is I think you and others have said there's a way for the progressives, depending on the case, to wield that doctrine against the conservatives. Am I right?
Yes. So I think it's a little early to know exactly how they're going to apply this doctrine, in part because they didn't bother announcing it until the Clean Power Plan case, formally. Neither did they really think to apply the doctrine while the Trump administration was doing some fairly significant things the first time around, such as, for example, creating a pretty broad exception to the Affordable Care Act's protections for health insurance coverage for contraception. So I am not exactly holding my breath to see the Republican appointees invoke the major questions doctrine against a lot of what Republican presidents are going to do, in part because the doctrine has baked into it some pretty jerry-rigged exceptions, such as, for example, in the case of immigration, or the case of maybe foreign trade. Like those are instances where the Republican justices have said maybe this might be less of a constraint on what the executive branch can do. And that, again, seems to give Republicans more powers in exactly the areas where they would like more power.
So can I ask you a strategic question then?
Yes.
So let's say, hypothetically, that you're on the progressive side of the court and the conservatives have come up with a crappy theory, a fringe theory that is also crappy, like the one you've just been describing in the minds of a lot of people. Then a case or controversy comes before the court. Do you on the progressive side, if you think that strategically applying that crappy theory would get the right and just result in that case, do you apply it and use it to try to convince your colleagues from across the ideological spectrum to join you? Or do you reject the crappy theory and figure out other ways, hoping that the crappy theory will one day fade away? How do you think about that if you're progressive justice?
I think this is a really difficult question, and it's part of why being a Democratic appointee on the Supreme Court is probably not the easiest, most fun job right now.
Right.
And I think the answer is it's probably going to depend on something of a case-by-case, doctrine-by-doctrine consideration. I think there are some doctrines whose very premises are so hostile to the foundations of a liberal constitutional democracy or are so ideologically inflected that it's probably not worth trying to wield them or salvage them in cases where you might be able to use them strategically. Instead, better to maybe write separately and say, I think this regulation or this statute or this executive order is illegal for other reasons. And if your Republican colleagues are willing to apply the doctrine in consistent ways, they should reach the same conclusion. In others, the underlying doctrine might be, let's say, lawless, as in not super grounded in the law, but not necessarily one whose premises are antagonistic to the country being a liberal constitutional democracy. In that case, the calculus might be different. And if, let's say, your Republican colleagues are really only going to apply the doctrine in consistent ways or reach a particular outcome if you're there with them and you join their opinion, then sure, right, in that instance, I can absolutely see the case for going along. But I think it's really a complicated calculus that's likely to vary case by case, doctrine by doctrine, and is also going to depend on your assessment of what you think your Republican colleagues are likely to do.
Okay, ready for the next one?
Sure.
Is or is not originalism a fringe theory?
I think originalism is basically a way of shoveling fringe theories into constitutional law. I think
so it's very meta. It's like the meta fringe theory.
Yes, exactly. It's like the funnel for fringe theories to get into constitutional law. Originalism kind of as an idea, in some respects, I don't think is necessarily a fringe idea. I think it was kind of propounded as an insurgent theory to roll back a lot of, the 20th century. But, the notion that we should interpret legal texts, what they meant when they were enacted is not necessarily out of bounds. I just don't think it's a great fit for our Constitution for myriad reasons, in part because when the Constitution was drafted and ratified, it was drafted and ratified in undemocratic ways. So using originalism is only going to perpetuate the democratic deficit in our Constitution and constitutional law. So, but I don't think it necessarily has to be a fringe theory on its own rather than a vehicle for them.
You're pretty generous to originalism there.
I try.
All right, so let me ask you this question. Was the idea of the right to privacy in the Constitution a fringe theory, say, in 1958?
I am going to say no, but I want to explain that kind of in 3 different ways, if that's okay. I'll try to do it quickly.
So for people to understand, why I'm asking the question, some of these seminal cases about a right to privacy that is not stated explicitly in the Constitution was found to exist in the Constitution, largely in a series of cases post-1958. So, okay, go ahead.
So first, I think the idea that the Constitution protects some rights that are not specifically or explicitly mentioned in the Constitution's text is absolutely not a fringe theory. There's just several indications in the Constitution that there are such rights, from the Privileges and Immunities Clause, which doesn't define what the privileges and immunities are, to the Due Process Clause, which doesn't define what a constitutionally protected liberty is. So it's not, I think, outlandish to think the Constitution does protect some rights that are not specifically and explicitly mentioned in the Constitution's text. Is the right to privacy one such right? I think around the time that the court is establishing and defining the right to privacy in cases like Griswold versus Connecticut, which involved a restriction on contraception, that is around the time of sexual revolution in the country coming around to more civil libertarian instincts that, the release of the Kinsey report suggests Americans are a little kinkier, than previously realized. And maybe it wasn't the government's job to kind of impose particular sexual mores on them. So I don't think it was a fringe theory in the sense that it was catering to a narrow segment of the country or imposing, right, like a narrow segment of the country's views on everybody else's. So it doesn't really fit, the definition of a fringe theory, I think, in some important respects. Obviously, it struck some people as quite odd and problematic. And I understand why people are nervous about the prospect of rights being protected that aren't spelled out in so many terms in the Constitution, but it would not be a fringe theory in the way I think about it.
Let me ask you about some things that are going on right now. It seems like the most important question before the Supreme Court, or will be before the Supreme Court, but it's wending its way through the courts up in the area of immigration, but not just only in the area of immigration, is the issue of how expansive is the executive branch's power, right? By the way, while we're transitioning to that, let me ask you one more question about a fringe theory. Is the unitary executive theory a fringe theory?
That one I will go all in on being a fringe theory.
Okay. What is it and why is it fringe?
Unitary executive theory, I'm just going to describe generally as the idea that all of the executive power is vested in the president, and importantly, that the executive power contains many more things than are specifically listed in Article 2 and contains things other than the power to execute laws that are created by Congress. The reason why I think that's a fringe theory is, it's really kind of trotted out during the Nixon administration and the Nixon administration's quest to seize more and more power and exercise power in abusive ways, whether that is investigating political opponents, whether that is declining to spend funds appropriated by Congress, and a host of other overreaches and abuses. And I also worry that the unitary executive theory is, in important respects, inconsistent with a system of separated powers and rule of law, because it allows the executive branch to be above the law in important respects. Congress cannot place some restrictions on the president, cannot, for example, insulate certain officers from presidential removal because the president gets to execute all executive power. It could call into question things like the civil service. And so I think the implications and the premises of the theory and its origins, I don't know, I'm willing to put that in the fringe theory bucket.
Hey folks, by now, you know what you got to do. Can't miss any episodes of the show. It's very important. And the guests will get upset if you do. Hit that subscribe button.